Meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room as well as remotely using the Zoom application. I'd like to make a few comments for the benefit of witnesses and the members as well. Before speaking, please do wait until I recognize you by name. For those participating by video conference, do click on the microphone icon to activate your mic and do mute yourselves when you are not speaking. For those in the room, your mic will be controlled as normal by the proceedings and verification officer. You may speak in either official language of your choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. If interpretation is lost, please inform us immediately. In accordance with the committee's routine motion concerning connection tests for witnesses, I am informed by the clerk that all witnesses before us, appearing before us virtually, have completed the required connection tests in advance of the meeting. Now, pursuant to Standing Order 1082 and the motion adopted by the committee on Wednesday, September 21st, 2022, the committee resumes its study of Canada's sanctions regime. I'd now like to welcome our witnesses. As an individual, we have Andrea Charon, professor from the University of Manitoba. We have Madame Sophie Marino, PhD candidate. And we have Dr. Craig Martin, professor of law. And Royal United Services is here right now, too. And sorry, my apologies, we have 4 witnesses. And the fourth witness we have is Tom Keating, who is the Director for Center for Financial Crime and Security Studies. Each of our 4 witnesses will be provided 5 minutes for their opening remarks. And I would ask that you do pay attention to the monitor, because when you're getting very close to the 5 minutes, I will hold up a sign, and we would be grateful if you could wrap it up within 30 seconds of that. The same goes when members are asking you questions. Each member is allotted a particular time frame. So when you're approaching that time frame, I will hold up the sign. Now, we will start off with Madame Andrea Charon from the University of Manitoba. Are you ready to take the floor?
I'm ready.
Excellent. Okay, well, you have 5 minutes. Thank you.
Thank you for the opportunity to present my recommendations. I have 3 immediate ones, which have been outlined in numerous reports, including the latest report published by the Senate in May 2023. I note this current review is limited to Canada's autonomous sanctions legislation, but a review of the machinery and architecture of all of Canada's sanctions legislation and procedures for multilateral, autonomous sanctions, and the Freezing Assets of Corrupt Foreign Officials Act, which applies to Ukraine and Tunisia, is recommended for the future. The 3 priorities are to better coordinate with our legislatively closest allies, the EU and UK, to report publicly on measures of effect and effectiveness in a yearly report to Parliament, and to develop Canadian-specific training and proactive guidance. First, the EU and UK have similar autonomous legislation to Canada. They do not have extraterritorial reach, as does the US, and they sanction for similar reasons, as does Canada. But there are differences. The EU has matched 9 of the 11 CIMA regimes and has also sanctioned different states from Canada, example, Bosnia-Herzegovina, but no longer has sanctions against Sri Lanka and sanctions China differently from Canada. Canada recently adopted a 50% ownership rule, but it matches the US for 50% or more, and not the EU and UK's over 50%. The EU and UK provide public reports on sanctioning activity and publish far more information on targets that is more easily searchable than does Canada. While variation among the sanctions regimes is expected, particular attention should be paid to targets listed by some states and not by others. This encourages sanctions busting shopping, where targets seek to export, import, or store assets in the non-sanctioning states, delegitimizing Western resolve and coordination. A recent study by me, Dr. Tillahoon, and Ms. Cherpaco in 2021 found that only 8 individuals and 1 entity out of over 2,000 listings, or 0.4% congruence rate, were the same for both Canada and the EU for human rights abusers. Next, Canada needs to publish and review measures of effect against the target and effectiveness for the sender on a regular and consistent basis. For too long, Canada has sought to improve sanctions efficacy by creating more legislation and adding new requirements, such as a mandatory inadmissibility clause, to sanction thousands of targets, but the government cannot answer the question, are its sanctions effective? Easily attained measures of effect can include import and export changes with the target state, the gender of targets, type of entity sanctioned, is it state-based or private, what types of goods or services do they produce, the number of delisting requests versus success rate or denial rate, and the number and type of retaliatory sanctions against Canadians. Effectiveness measures include, but are not limited to, objectives. Is it to protest undemocratic changes to government, decry human rights abuses? What's the purpose? Is it to coerce, constrain, signal, or stigmatize? And the targets, are they elites? Are they state-owned entities? And the number of permits sought and issued by Global Affairs Canada to authorize activities otherwise prohibited, and requested by whom? Categories could include individuals, businesses, or NGOs in the activity. Finally, what about the number of court proceedings versus prosecutions or dismissals? And finally, as part of establishing a specialized sanctions bureau, it's incumbent upon the Government of Canada to ensure that the officials involved in administering Canada's sanctions receive training on the specifics of Canada's sanctions regimes and sanctions research generally. And I agree with Lawrence Herman that Canadians and Canadian businesses need proactive written guidance on sanctions application. After all, they are the first enforcers. Training and guidance will improve policy making and enforcement. A number of academics are ready to assist and provide such curricula in their law, businesses, and public affairs courses. Thank you.
Thank you very much, Professor Charon. We will now go to Madame Marino. You have 5 minutes.
Merci beaucoup.
Thank you very much. The study analysis of previous sanctions has shown that sanctions don't stop wars, yet sanctions regimes are still widely used by Western governments, even if the results are always uncertain. If war is not an option, then sanctions reveal that even without binding means, it is possible to express disagreement, at least symbolically and diplomatically. The imposition of sanctions is a relatively inexpensive political instrument when compared with armed conflict. However, it's impossible to define the exact level of measures required to have a real impact on the policy of the sanctioned states. However, certain factors are decisive in determining the effectiveness of a sanction regime. The most important factor is certainly the economic cost imposed on the sanctioned state. The higher the cost imposed on a state, the more likely it is to change its policy. The second factor concerns the type of political regime in the sanctioned state. Sanctions are far more effective when used against a democracy rather than against an autocracy. The third factor concerns stability. A state that is rather weak or suffering from economic problems will be more vulnerable to the application of a sanctions regime. Even an autocrat with little concern for the well-being of its population will actually have difficulty managing a state that's on the brink of chaos. The fourth factor refers to the link between the sanctioning state and the sanctioned state. For sanctions to be effective, the economic relationship between the sanctioning state and the sanctioned state must be significant and well developed. If trade is significant, the sanctioned state will lose a more important source of revenue than if trade is limited. A fifth factor relates to international cohesion. Sanctions must be applied by the majority of the sanctioned state's economic partners to maximize their chances of success. If there's a lack of international cohesion, within the sanction state may find alternative suppliers to those who are imposing the sanctions. A phenomenon such as rally around the flag is a factor that limits the effectiveness of a sanctions regime. In certain cases, if civil society believes that its country should not be placed under sanctions, we can witness strengthening of national cohesion around power. This phenomenon can also operate in an entirely different vein. If a people is too dependent on its rulers for its supply of food and basic necessities, civil society may rally behind its rulers because, as Andrei Kolesnikov has explained, who's a professor of law at Moscow University, people prefer to support the hand that feeds them because if it were to disappear, they may not be fed at all. Finally, time is also an important variable in determining the effectiveness of a sanctions regime. Sanctions often force sanction states to turn in on themselves, develop their own industries to become self-sufficient, or find new economic partners to replace those who've been lost because of sanctions. In the long term, this phenomenon has the effect of making the sanction state more apt to live in autarky or less dependent on imports and goods from sanctioning states. The effects of sanctions then become extremely limited. In the specific case of Russia, I'd like to quote analyst Perun to illustrate what we can expect from a sanctions regime. They said in English,
"Has forced you to spend the time and the money to evade them. They are not so much bullet wounds as mosquito bites." C'est par l'effet cumulatif de tous ces désagréments que les sanctions.
it is through the cumulative effect of all these inconveniences that sanctions become effective. At present, around 70% of Russian banks' international assets are inaccessible under sanctions. At the same time, some 20 billion euros worth of assets of over 1,500 sanctioned individuals and entities have been frozen. In the past year, Russian exports have fallen, while imports have risen. Almost a third of the Russian budget is devoted now to military spending, which has the effect of slowing down Russian economic development. It is certainly difficult to isolate the impacts of sanctions alone, let alone the impacts of Canadian sanctions alone. But as an international cohesion is paramount to the success of a sanctions regime, Canada's efforts must be analysed in a more global perspective where the efforts of all partner states actually count. Thank you very much.
Madame Marino.
Thank you very much, Madame Marino.
Dr. Martin. Dr. Martin, you have 5 minutes for your opening remarks. Dr. Martin, we can't hear you. Mute button. Thank you.
Sorry about that. Thank you, Mr. Chairman, and thank you, honourable members of the House. Thanks for the invitation to appear before you today. It's really an honour to be here. At the outset, I'd like to applaud the work that you are doing in conducting this important review of Canadian economic sanctions law and policy. By way of overview, my focus is on the broader international law issues implicated by the Magnitsky Law and CIMA. I believe I was invited because of my policy report, Economic Sanctions Under International Law, A Guide for Canadian Policy, which was published in 2021 by the Rideau Institute and the University of Ottawa Human Rights Research and Education Centre. And I do commend the report for your review, as I can't possibly do justice to the nuance and complexity of all of the issues that were analysed in there. But in short, I suggest that there's a tendency in the Canadian sanctions discourse to simply accept that autonomous sanctions, and that is sanctions that are not authorized by the UN Security Council or some other international legal organization, are lawful. There's this assumption that if all of our allies are imposing similar sanctions regimes, they must be legitimate and they must be lawful. And indeed, the view is that such sanctions are not only lawful, but virtuous and are the best way to peacefully enforce human rights and other international legal obligations. And this view was largely echoed in the recent Senate committee report based on hearings that it conducted last year. And while I commend some of the recommendations that the report made for improving Canadian sanctions regimes, it too largely accepts this assumption that autonomous sanctions are lawful under international law. But this somewhat uncritical view neglects serious questions that are being asked in international institutions, in international legal scholarship, and in the statements and practices by states in other regions of the international community regarding the legality of certain kinds of autonomous sanctions. Indeed, there are sharp questions as to whether certain kinds of sanctions, including the kinds of sanctions that Canada participates in, often imposed in the name of human rights and the international rule of law, do not themselves violate international law obligations in various ways. First, for instance, whether they do not themselves actually violate human rights norms and obligations, whether in terms of comprehensive embargoes that cause humanitarian suffering in target populations in a manner that violates human rights law, or in terms of targeted sanctions that may violate the due process rights of individuals who are being targeted. or second, whether they may constitute unlawful intervention in the sovereign affairs of target states in violation of well-established principles of non-intervention, or third, whether some targeted or secondary sanctions may violate international law principles on jurisdiction, which prohibit the extraterritorial application of domestic law, all of which potentially, rather paradoxically and ironically, undermine the international rule of law that sanctions are trying to enforce. These questions are even sharper with the recent suggestion that Canada would not only freeze the assets of certain targeted individuals, but actually expropriate those assets and convert them for purposes of reparations to victims, such as in Ukraine, all in the absence of any trial or other legal process, which is viewed by many international law experts as being inconsistent with well-established international law on expropriation. What is more, critical arguments about sanctions are more strongly made by states in the global south, precisely where Canada has traditionally tried to champion the rule of law and human rights compliance. There are thus potential tensions between the human rights objectives of Canadian sanctions law and policy, the effectiveness which are often very much in question, and the possibility that such law and policy causes real harm, undermines Canada's broader foreign policy objectives, makes it vulnerable to charges of hypocrisy, and is indeed inconsistent with its own constitutional values. In closing, let me just say that this has only been a thumbnail sketch of what are really very complex set of arguments and analyses, and I'm happy to address questions on any of the issues in more detail in response to questions. And I don't want to overstate the case. Many of these questions that I addressed regarding the lawfulness of sanctions are unsettled and contested. But that unsettled nature of these issues calls for caution. And the primary point I'd like to leave you with is that the Canadian government has not done enough to publicly address these questions, to explain how its sanctions, law, and policy complies with international legal obligations. And I would suggest that there are ways in which Canadian law and policy may not be consistent with international law or certain Canadian values, and that even doubts regarding Canadian noncompliance can operate to undermine Canadian efforts to strengthen human rights and the international rule of law. Thus, in my view, Canadian law and policymakers need to be more sensitive to these international law implications, develop and implement sanctions law and policy more fully informed by the relevant principles of international law, and to provide a fuller and more detailed public explanation of how such law and policy is compliant with international law. Thank you very much, and I look forward to your questions.
Thank you very much, Mr. Martin. We now go to our last witness, Mr. Keating. The floor is yours. You have 5 minutes.
Very good. Thank you very much, and thank you for inviting me to speak to you today, this evening. So as mentioned, my name is Tom Keating. I run
Mr. Keating, 1 second, please. So sorry, the clerk wanted to advise us of something. Yes. Mr. Keating, we just heard from the interpreters. They're having a hard time hearing you. So as I understand it, you did receive headphones from the house?
No, because I've been on holiday and I came back at midnight last night in order to participate. So I'm wearing a Logitech headset, which I have owned for a couple of years.
Absolutely. So you do not have access to House-issued headphones. The interpreters are saying that this is against the regulations of the House. The clerk is advising me.
We have guidelines for House.
So can we still ask questions of the witness, or? My apologies.
I just went through a sound test 45 minutes ago. And
Yes, that was my
was cleared to participate.
For sure. Yes, that was my first question to the clerk as well. But I'm afraid we've been advised that we can't proceed with your opening remarks because they are having difficulties, and those are the rules. Terribly sorry about this, Mr. Keating. Obviously, we would very, very much like to hear your views. Would it be possible for you to submit your remarks for the consideration?
I submitted them already in advance last night, having written them on holiday at the request of your clerk, and I'm now having my time wasted, which I'm afraid is not. I take a pretty dim view of that.
I'm terribly sorry. Those are the regulations and the rules here. Do the members have anything to say? Yes, Mr. Abeltaise.
So do you want any perspective from across the Atlantic, or shall I go?
We're trying to sort this out. I will have to rely on the members to provide suggestions. Yes, Mr. Abeltaise.
With the permission of all members, I think if we can all gather with English what the professor is trying to say to us, let's allow him to do his presentation, and then, again, with the permission of everyone.
Perron?
I'm sorry, Chair, and I'm very sorry vis-a-vis Mr. Keating. Perhaps he can be invited back, but unfortunately I cannot agree to that. It's part of our directives, and it's in full respect for interpreters' work. We have to understand that the auditory health of interpreters is constantly put to the test in hybrid parliament, and that's why we wanted to limit hybrid parliament in our political party. So I cannot give my agreement. I'm very sorry.
I'm terribly sorry, Mr. Keating, given that those are the House rules. We cannot override them. I do apologize to you. I understand that there were unique circumstances that you faced in not being able to obtain them or to receive them. But
for the avoidance of doubt, 1 hour ago, I did a test with the interpreters who approved approved my participation. Now you're basically humiliating me in front of the Canadian Parliament with this decision. I cannot tell you how embarrassing this is.
I can assure you that is not the objective. The rules state that we're not allowed to proceed.
But why did the interpreters agree less than an hour ago?
You raise a very, very valid point, Mr. Keating. But that is
indeed there was a further discussion about this, and then I was told, please continue. I'm
terribly sorry. I completely understand your frustration.
Thank you,
Ms. Chattel.
Thank you, Mr. Chair. I'm very terribly sorry, and that happened before in other committees. The rule have been very, very strict now because of health issues with our interpreter. It's really nothing about you, Mr. Keating. It's really about the safety of our interpreter, and it's a rule now. It has created similar issues in other committees. What I've learned is that there is a technical test, but not necessarily in presence of the interpreter that are assisting our committee. But I really.
But I thought. I'm sorry to interrupt, but an hour ago I did it in the presence of your interpreters. I was told.
Mr. Keating, allow me to emphasize once again: those are the rules of the House, and we apologize for the inconvenience.
I like the suggestion of Monsieur Perron. We really would like to hear about your testimony. I think it's very important for this committee. And with your permission, Mr. Chair, I would like to make sure that we invite and with the right headset for another moment. But I would really like to hear about our witness today, on this committee. Thank you.
I apologize to my fellow witnesses for this shambles.
Keating, this is not shambles. We all very much would have liked to have heard from you, but the House does have its rules, and this is not unprecedented.
Okay, well, I tell you what. Let me save everyone's time. I will hang up on the call. You can continue on your hearing. If the clerk wants to get in touch with me and invite me back, then we can figure something out. If I can be available. But needless to say, this has not been a good experience with a fellow ally across the Atlantic on one of the most important topics that we face right now in international security. And I would have thought you'd want to hear from the view from Europe, where obviously sanctions play a critical role in response to Russia's
Mr. Keating,
full-scale invasion of Ukraine.
my sincerest apologies. We do want to hear from you, and someone will be in touch with you. Thank you kindly for your time.
Mr. Chair, point of order.
Yes.
Mr. Chair, this is deeply embarrassing, and I would hope that we don't end up in this situation again. If somebody is cleared an hour ahead of the meeting or half an hour before the meeting, then they should be able to proceed. So I don't know what happened, but he should never have been cleared half an hour before the meeting to proceed. So let's make sure, Mr. Chair, that this doesn't happen again, because this, frankly, is embarrassing.
I agree. I mean, that process is in place for a reason, but we can talk about that in committee business, if that's okay with everyone. So now we will open the floor to questions from members. For the first round, we have 5 minutes each. Mr. Hoback, you are up first. You have 5 minutes.
Well, thank you, Chair. And again, this is unfortunate this happened. So I want to thank the other witnesses for being here this afternoon or evening, depending where you're located. One thing about having sanctions on a country or on a person or an individual, they're only as effective as the country putting the sanctions on's ability to enforce the sanctions. So what recommendations would you make in light of the fact that Canada has not been doing that, that we should look at as a committee to see better enforcement and better follow-through in regards to these sanctions when they're actually put in place? Maybe I'll start off with you, Mrs. Sharon, and go to Ms. Marteau and Mr. Martin at the very end.
Thank you. That's an excellent question. And I think what we've heard from a lot of the testimony is that ultimately the RCMP and Customs Border Services Agency, et cetera, are responsible for enforcement of sanctions. But that's actually not quite correct. It is, in fact, Canadians, Canadian businesses, Canadian banks and financial institutions who are on the front line of making sure that they understand sanctions and are able to make sure that they're not dealing with listed entities and individuals. And so that's why I'm calling for sanctions training, which Canada does not have, unlike the EU and UK and US, and that we don't provide guidance to Canadians. For example, Guinea-Bissau is sanctioned by the UN Security Council. We are obligated to put in place those sanctions. You will not see Guinea-Bissau mentioned at all on the Global Affairs website. We are missing information that allows Canadians and businesses to actually do their job and make sure they're at the front line of sanctions enforcement.
I only get 5 minutes, so we'll have to be very quicker with the other two witnesses. Just wouldn't mind to have your comment on that, just quickly.
Oui.
Yes. In the last few years, I've often received questions about the clarity of Canadian sanctions. On several occasions, people were finding that the legislation was rather vague, in particular as regards sanctions. Last year, there were Bombardier engines in Shahed, drones built in Iran, used by Russia, and they were then found on Ukrainian territory afterwards. So it's not extremely clear for everyone whether Canadian companies are really respecting the sanctions or not. And in this specific case, the engine was classified as a civilian use good rather than a military use good. it's far from clear for most companies and the population to know what is a civilian use good versus a military use good. And even when it comes to classification on the Canadian government website, it's not very clear either, far from it. So it takes a great deal of research amongst the companies to know whether their goods or property is covered by sanctions or not. And that's bringing in a great deal of vagueness in the regimes that are being currently imposed.
5 minutes. So, Mr. Martin, I'm just kind of curious. You've done a lot of international work in regards to this. When Canada isn't perceived as doing its share of the work when sanctions are put on, how does that impact our relationship with other countries around the world? And are we taken seriously around the world when we say we're going to put serious sanctions in place and then we see no enforcement on the back end?
Well, I would say that it's not exactly my area of research, but I would say, and I think that Professor Charon, had her finger on the fact that when we think about enforcement, there tends to be this sort of focus on whether there are prosecutions, and yet that sort of misses the point that sanctions often have their effectiveness in the way in which, for example, financial institutions refuse to process transactions. Lawyers advise their clients not to engage in certain trade. And so sanctions can actually have quite a profound effect, even without any evidence that the law enforcement is actually prosecuting anyone for violation of sanctions. So you'd have to do a lot more granular research to determine whether, in fact, the sanctions are being violated in a way that would require prosecution. And in terms of the international perception, the thing that has been getting the most attention from my perspective when I'm at conferences where both legal scholars and law and policy experts are convening, the thing that is getting the most attention is Canada's suggestion that it may start expropriating assets as opposed to just freezing assets. And people are thinking that Canada is actually way out in front of everybody else, and perhaps not in a good way, in terms of pushing the boundaries of international law with respect to expropriation.
Mr. Martin, I'd like to talk to you more about that part of it too, because I think that's a very important conversation we should be having. But it comes back to, again, though, if there's no benchmarks, if there's no transparency, if there's no way of seeing exactly what's going on, how do you know whether you're being effective or not? How do you know that companies are actually obeying? You say that you think they are, but I have no measure or no tools to say that you're right or wrong. So maybe back to you, Ms. Charon. What type of benchmarks should be put in place, and how do we make sure that they're established in such a way that we get good data?
Well, I think you've hit the nail on the head, and these testimonies have provided lots and lots of data, but it's not captured. It's not given to the public. And this should become routine. Our other allies provide, here's a summary of our sanctions regimes for the year. Here's the number who asked for delisting and the like. And then that provides metrics to determine if, in fact, for Canada, we determine things are effective. Right now, the only metric we have is how long the lists
Sharon,
are.
you're out of time. Considerably out of time. So my apologies for interrupting you. I'm sure another member will ask for further clarification. We next go to MP Zuberi. You have 5 minutes.
I'd like to thank all the witnesses for being here. Merci tout le monde d'être ici aujourd'hui. I'd like to start with Professor Charon. In your brief, you mentioned that annual review of sanctions would be a good thing. Can you just elaborate a little bit about what the value of an annual review would be in your estimation?
Thanks. Well, as Sophie mentioned, the whole effectiveness of sanctions requires the sender to be reactive to events on the ground. But Canada has a fire and forget. We put a name on a list, and then that's the last we hear from it. We know that Canada, for example, took 3 years to lift sanctions from Cote d'Ivoire and Liberia after the UN Security Council had. So we spend a lot of time up front on who to target, but we don't spend a lot of time on what's the effect on these targets. And then should we be maybe adjusting with allies and with events on the ground?
Perfect. An annual review, don't you think that would be a little bit onerous, though? Wouldn't you suggest maybe every 2 years or something along those lines? Number one. Number two is, do you have any thoughts? This is just an open question without leading you anywhere. but with respect to some sort of sunset, something along those lines, or review mechanism that would require renewal. Do you have any thoughts, Professor Charron or anybody else?
Well, I think it's not onerous because the information is readily available. It requires somebody to put it together. And the first time when you think about the formatting, that's going to be difficult. But we have legions of really smart graduate students who you could throw at this and they would have this licked easily. So I think it is possible. But we have to determine the format that we need. Oh, and on the sunset clauses, well, it depends. On the one hand, it then tells targets, I just have to sit it out and I'll be fine. And I'll make sure that I do my bad behavior after the sunset clause has ended. What it really requires is for regular reviews with all of the players and with allies to be responsive to events on the ground.
Et Madame Martineau, sur votre...
So, Madame Martineau, you commented on the negative and involuntary consequences caused by sanctions. Could you elaborate on that?
On this?
Pouvez-vous répéter la question?
Could you please repeat the question in English for me?
On your social media, you mentioned something along the lines of unintended consequences with respect to sanctions and negative consequences. Would you like to elaborate a bit on this?
Oui,
Yes. You'll tell me if I've understood your question correctly. When we impose sanctions, necessarily we stop or we try to limit trade between a foreign country and Canada. So in order to stop this trade, there has to already be trade. And in this specific case, Russia is suffering the consequences, but Canada as well. So with effective sanctions, there will be an effect on the sanctioned state, but it can also have a knock-on effect on the sanctioning state because normally it's a bilateral relationship or sometimes a multilateral relationship, but it's certain that Canada or any other ally country has to deprive itself of exports and imports with Russia, and so there's deprivation of revenue or goods. So that means that sanctions do have a knock-on negative effect on the Canadian economy. If we're looking at the effectiveness of sanctions together with our allies, does that answer your...
What is the value in harmonizing or working in coordination with other countries with respect to our sanctions? Would any of you like to elaborate on that point?
May I start? Oui.
If I could ask that you provide very brief response, 15 seconds, please.
Oui. Donc, dans l'étude des...
Yes, in studying sanctions regimes, when there's no international cohesion, the sanction state can quickly find other alternatives compared to the sanctioning state. So when we've got international organizations such as the EU, which impose sanctions with all of the strength of the partners behind them, it's far more effective than if it's just one country such as the US and the embargo in Cuba. Cuba is able to replace the US client by other clients. So if you've got more clients, it's more effective.
Monsieur Perron, vous avez 5 minutes.
Mr. Perron, you have 5 minutes. Thank you very much, and thank you to the witnesses for their time with us today. Madame Martineau, I find that you've detailed well the factors to look at the effectiveness of these measures, these sanctions, but it's a shame that this is not actually being used in 2020 or rather in 2022, there was 76 million. There was announced to set up a specialized sanctions office to deal with all of this, but we haven't seen this office yet. So do you consider that this is a normal delay given the structure to be set up? Do you think we're being rather laxist, and should we expedite this? And if I've correctly understood what you've said, you've also said that this office should also report to the House on a regular basis. Could you perhaps clarify that to me? Well, I don't think I'm actually the one who talked about this. I believe it was my colleague, Professor Charon. Well, I was coming back to your own factors, Madame Marino. Do you think it's normal that we don't have a structure that's doing this in spite of the announcement last year? Do you think that expeditiously we should set up this specialised sanctions office? Do you think that's a recommendation that we could make to the government as a result of our study? I think that would be a good recommendation to be made by the committee. If we set up sanctions, then we have to means to test the effectiveness of these. Effectiveness of sanctions cannot be just calculated in a few days or a few months. We're talking about a sanctions regime that was set up first of all in 2014 and then further beefed up on several occasions in the meantime, with new stricter measures as of 2022. So normally we should be able to see results for 2014 to 2020, 2021 at least, and then soon, hopefully, we should also have the data that's necessary to estimate the effectiveness of the sanctions and measures that were implemented last year. Thank you. I think you were the one who referred the question of having regular reporting. I imagine you agree that 1 year is sufficiently long and we should see this office being set up very quickly.
To me?
Oui, Madame Charon.
So I think I think we can't underestimate how difficult it is to pull people together to get them trained. We don't have a culture of sanctions certification in the U.S., UK, EU. They have sanctions certification. They go on regular courses. It's recognized worldwide. Canada is, a day as part of that certification, and too few of us take that certification. So one of the problems is going to be trying to find people to hire, but then bringing them up to speed, because this is a really complicated topic.
Thank you very much. And now to come back to Ms. Marino with your criteria for evaluating the efficacy of sanctions, do you think that overall the sanctions that have been imposed by Canada on Russia are actually effective currently? Well, to come back to my opening statement, I would say that the sanctions do not stop wars. Historically speaking, if we analyse recent sanctions regimes in the 21st century, we cannot say that the sanctions against Russia will stop the war, but we can expect that sanctions should create economic difficulties in Russia, quite significant economic difficulties, so that at one point in time, Russia actually wants to or decides to join negotiations to get out of this war. So are these sanctions effective? We've clearly seen the effects of this when it comes to the military-industrial complex in Ukraine. Russia's obliged to use Soviet arms and dust off tanks that date back to the USSR days. So are the sanctions working? Yes, we're depriving Russia of certain goods and the parts that it needs to develop its industrial military complex. So in all cases. Well, thank you very much. Well, what I've understood from what you've said is that I'm happy that you're saying that the sanctions are working, but then there's the question of international cohesion. We need to be several countries doing it at the same time because the economic weight of Canada means that we can't do this alone. So international cohesion. You've referred to that in your research. You've talked about black knights and countries that help them to evade these sanctions. Can you talk a bit more about these black knights? Who are they? And how could Canada act to actually stop these black knights from acting?
Le principal allié.
So the main ally and the main economic partner of Russia at the moment is China. And since 2014, Russia has been quickly turning towards its Chinese partner and has almost become dependent on China for many import and export markets. And I would say, well, other partners would be within the BRICS so countries who are trying to challenge the current international order. Thank you.
Thank you. Next, we go to MP McPherson. You have 5 minutes.
Thank you very much, Mr. Chair. Thank you to the witnesses for being here today. This is a very interesting conversation, and like some of my colleagues, I would love to sit and spend an awful lot of time picking your brains, but we have a very quick amount of time here. Dr. Curran, or Ms. Curran, you had spoken about. You testified before this committee in 2016 about the study of Canadian sanctions, and you spoke a lot about your concerns with Canadian sanctions practices. You know, the committee report made a series of recommendations. We haven't seen a lot of those recommendations followed through on. So I have two questions for you with regards to that. First of all, what is your assessment on how well the government has responded to that report? How well do you think that they have met the recommendations or responded to them? And I'm going to assume that you're going to say there's some things, at least in part, wanting from that, and why you think that has been the case. You know, considering the fact that this is something that is key, that has become an increasing part of our foreign affairs international policies, why do you think these recommendations are so slow to be implemented? I sort of answered in there. Sorry about that.
Yeah, that's a great question. And the fact that we have the same recommendations that come up time and time again, and they're on the list and they don't seem to get ticked off is I think, the metric that we're not advancing. But I would say this is not unique to any one party. This has been a long-standing problem. I started raising the concerns, back 15 years ago. And, we need to get a handle on our legislation. It's a bit sloppy. It doesn't, there's no coherence. And we're here again. And I think because there is a merit, political merit in putting names on a list. For Canadians, we're doing something. But now we realize that's not sufficient, and we actually need to integrate and coordinate with allies. And now we need to get down to the business of measuring how are these having an effect, because it's a much more complicated world.
Well, yeah, and I think one of the things, for you to call some of our sanctions sloppy, that it's easy to put someone on the list, that we don't have that follow through. Last session we heard from witnesses that said that the rest of the world that we are sanctioning is in fact laughing at us because they know that they don't have any teeth to them, that these sanctions don't mean anything. So from your perspective, do we have the ability do the sanctions mean anything? We have also heard today that they are working with Russia, but do you think for the majority, are they actually doing anything? Do they even have a political value in terms of signaling to other countries our displeasure with their actions?
Well, we can't answer that question unless we measure it. And I will say that Canada has some of the best public servants in the world, but they are beleaguered. They don't have enough resources. We've had a tsunami of sanctions, and perhaps we need to put the brakes on and say, look, it's not about the number on the list. Let's maybe look at the list and see how we can make those individuals and entities make sure that we've got the right people. And this requires conversations with our allies.
And that's just it, right? Because if we have a tsunami, as you say, of sloppy sanctions, it doesn't help us. It doesn't do anything. It's better to have those targeted ones that are actually being enforced. You also spoke to the CBC previously about the lack of qualified investigators, technical experts. You spoke today on this panel just about the fact that we don't have the people in place. First of all, are there other countries that are doing that better that we can learn from? I know you indicated the U.S. I'd like you to talk a little bit more about that. And then how do we do that? How do we get those skilled people in place? What are the next steps that the Canadian government needs to take?
Well, I'm sure Craig Martin is going to have some advice on this as well, but there are a series of associations that provide sanctions training and certification. You take an examination and it goes through EU, UK, US sanctions. They often spend, sort of a day on Canada, usually are blocking legislation for Cuba. But we just don't have this sort of culture of certification. And I think it would extend to money laundering as well. These are connected enacted, and yet we don't seem to have this culture of training. We don't see global affairs like we do OFAC officials in the U.S. saying, let's talk about the latest sanctions, and here are some basic, facts about them, and here's some guidance we can provide it. It's coming, it's improving, but it's going to take, Canadian-specific training that Canadians take, businesses take, our allies take, so that we can start to integrate and coordinate our sanctions better, and it will improve enforcement.
We go to the second round now. Mr. Abou-Taif, you have 3 minutes.
Thank you. Dr. Sharon, for the sake of a short time, I've got 3 short questions that probably require short answers. The first one is, if you had to rate Canada's transparency measures for sanctioning, how would you rate them?
Poor. We have very little information about sanctions that's publicly available, and on targets, we often don't even get birth dates.
Considering Canada's cultural mosaic and the mysterious nature of our sanctioning system, do you believe the Canadian public should be aware of the sanctioning processes?
Absolutely, we are required to. It says quite clearly, if you engage in sanctions-busting activity, you are obligated to contact the RCMP. So yes.
So do you believe, you mentioned the sanctions certification system, how much would you emphasize on the government to establish something like this?
Well, I don't think the government necessarily has to establish it, but they do need to inform some of the associations to make sure that the right Canadian sanctions training is being offered, and to encourage sanctions practitioners and people in the government that this this training is available, and to take it.
Is there a reasonable threat posed to the unity of Canadian society in not having sufficient transparency measures in place?
Well, I'm not sure I would go that far, but it does weaken Western coherence and legitimacy when, for example, the EU or UK sanctions, if they're going to sanction Gabon for their coup, but Canada doesn't, what does that say about Canada's respect for unconstitutional changes of government?
Do you believe, if these are some of the unintended consequences, do you believe that the government is taking into consideration the Canadian unity as far as approaching having a policy on sanctions systems?
Well, I've no doubt the government of Canada is always concerned about the unity of the country. I mean, that is one of the number one national interests.
In this specific term, please.
I guess I'm not understanding your question.
No, I'm saying, do you believe that the current policy is taking into consideration these things? That's why it's not effective.
Well, I think there are a myriad of factors. I don't think we can distill it down to one. If we just do one thing, all of a sudden everything will be terrific. It's really complicated, and we're asking the Sanctions Bureau to change the tires on a car while it's careening down a highway. It's really difficult.
Thank you.
Thank you. We next go to MP Oliphant. You have 3 minutes.
Just 3 now.
Yes, correct. Mr. Abou-Taif got 3 minutes as well.
Okay. Quick questions. Ms. Charon, you left an impression that I want to make sure you have a chance to correct if you want to correct it with respect to the difference between the autonomous sanction regime and the UN sanctions regime, as though we weren't sanctioning those. We now have 15 regimes at the UN, country and individual regimes, which on the GAC website are pointed to but not listed because of the complexity of the 5 or 6 different ways those happen. And you sounded as though we weren't sanctioning Guinea-Bissau or any of the other 14 countries that we were sanctioning. Did you want to just make sure that you are clear that even though they're not listed on our autonomous regimes, they are effectively being done the same way?
No, what I'm saying is the Global Affairs website is all sanctions, UN, autonomous, and the freezing assets. Guinea-Bissau is not listed because Global Affairs says it's only an inadmissibility sanctioned travel ban. We don't do travel bans. That's another department. So we're not going to list it on the Global Affairs website, except for Canadians. How are they to understand the totality of the sanctions if they have to know you need to go to the Immigration and Refugee Protection Act, and then you need to cross-list it with UN Security Council Resolution 2048 of 2012 to go and find the 5 names that are listed under for Guinea-Bissau, which we are obligated to do, but Global Affairs won't list Guinea-Bissau as a target state. That's what I'm saying.
But there is a direction to link to the UN website to do that. I'm just saying I want to be really clear that we follow rigorously all UN sanctions. We don't. They're not volitional. We do not choose involuntarily or voluntarily. We follow every single one of them.
Yes. However, how are Canadians to know? And that's the point I'm trying to make, is that at the end of the day, sanctions first and foremost are enforced by Canadians understanding them. If it's not listed on Global Affairs website, how are they to know?
We could probably argue that point because of the complexity of those 15 regimes that are now having 11 organizing committees, et cetera. But, we could get into that about whether it would be effective to simply list something or whether they need more information than that. I want to go to Ms. Marino, and I really found your 9 points very effective, and I've read them as well, and I wanted to congratulate you for helping us on it, because what is happening for me is that no matter what the problem is in Canada, we say, put in a sanction. Put in a sanction. And I hear it all the time. And if we're to follow your work on this, I think what you're saying is,
Mr. Oliphant, you're over the 3 minutes if you keep it very, very brief.
So if you wanted to comment on the fact that there is a complexity in sanctions that you are pointing to in those 9, perhaps intended or unintended consequences.
Oui, effectivement. Donc, les sanctions, c'est...
Yes, indeed. Sanctions are a means that we use because we're limited in what we can do. If we want to show to a state that we're against their policy. So to really simplify things, basically we don't do anything, we go to war, or we impose economic and diplomatic measures on a state. So often that's why we use sanctions.
So we go now to MP Bergeron. You have a minute and a half.
Merci, Monsieur le Président.
Thank you, Chair. A few days ago, Professor Thomas Junot said that sanctioned states had developed certain mechanisms to evade, to get round the different sanctions via, as you've said, Madame Marino, this mechanism of black knights that are undermining the cohesion of coordinated international sanctions. So how can we fight against the action of these black knights, which are allowing sanctioned states to actually circumvent these? Well, I'll take the question the other way around. What can we do to influence states to impose sanctions rather than restricting the action of black knights? So with Russia, we've got a sanctions regime which is being imposed by many countries, which means that certain countries are no longer historically neutral, such as Monaco or Switzerland. So it's a sanctions regime which is, as far as possible, effective because there are many, many allies involved. So can we ask China to impose sanctions on Russia? That would be extremely difficult. China is working on a very fine line with neutrality, where it doesn't want to encourage the conflict in Ukraine nor destabilize Russia, nor does it want to have worsening relations with the West. So it's not really about restricting black knights, but trying to rally round other partners to the cause of sanctions. I hope that answers your question. Unfortunately, I don't have any extra time to go any further. Thank you very much.
We now go to MP McPherson. You have a minute and a half.
Thank you. Dr. Sharon, you spoke about the fact that we have had a lack of transparency with how our sanction regime is being implemented. You just spoke recently about things not being available on the website, not being able to get that information. But we did have an announcement of $76 million that would go to this. That was last year. So, of course, you've been raising the alarm for a long, long time. And we had a study that came out with recommendations in 2017. You testified in 2016. Since the government's announcements last year of new funding for the Sanctions Bureau at Global Affairs Canada, have you noticed any difference yet?
Well, I am noticing there are sort of frequently asked questions that come up. But for example, our autonomous sanctions list is so clunky to search. Its targets are listed based on the order in which GAC puts them on a list as opposed to alphabetical. It's just things like that. The list may work for the government, but it's not working for the people who need to access the information to enforce the sanctions.
And realistically, when you talk about the fact that we need to get moving on this, that this is well overdue, this is not just one government, this is 15 years, this is a long time, the fact that a year has gone by with that $76 million and we haven't really seen the investment in folks that could be the experts in this area, folks that could do the enforcement, the training, the guidance, that sort of work, I assume you would see that as problematic.
It's complicated, but we're hemorrhaging people from the public service. So you're asking people to do, work of 10 people and, just could you add this on too and create a new sanctions bureau. So I have a lot of sympathy for public servants. I know this isn't difficult, and Canada generally is terrible with procurement. So if we need to buy software, it's going to take more than a year.
Thank you. We now go to MP Epp. You have 3 minutes.
Thank you, Mr. Chair. Thank you to the witnesses. One cannot solve a problem that one cannot measure, and I heard that in your testimony, Ms. Sharon. Specifically, can you point to one country that is appropriately measuring and appropriately reporting the effectiveness of their sanctions regime?
Yeah, and I would encourage you to ask Craig Martin this as well. But the EU and the UK provide yearly reports, and it's not in depth. It's sort of broad strokes information that helps course correct. The US provides all sorts of reports on their sanctions regime, so it is normally done by our allies, and I'm sure we could do it too.
Thank you. I will ask Dr. Martin to comment.
Thank you. So I totally agree with Professor Sharon, and I also think that the importance of these kinds of reports and the kinds of transparency that Professor Sharon was talking about, and she's absolutely right that the EU and the UK are far more advanced in this area than Canada. It's not just about measuring effectiveness, and by the way, when we talk about effectiveness, we have to stop and ask ourselves, well, how do we measure that when we don't actually necessarily even articulate clear objectives, right? So it's impossible to really talk about effectiveness unless you actually know precisely what the objective is. But there's also the importance in terms of sort of the human rights aspects, right? So particularly when we're talking about targeted sanctions, you have to have this kind of transparency and reporting in order to assess whether, in fact, the sanctions are targeting the appropriate person, whether the evidence upon which that sanctioning, that designation was based is still current, is it still accurate, is it still just, right? All of these factors are vitally important, and yet right now there is a lack of that kind of transparency.
Thank you. I want to follow up from your earlier testimony. You actually referenced, the aspect of a cost-benefit ratio, and you also and said again, a caution around the legality, if I understand, of the Canada sanctions regime with international law. To me, please explain to my non-lawful mind, I don't mean that the way it sounds, that is there a cost-benefit analysis in that?
Well, I mean, when you say a cost-benefit analysis, we have to sort of differentiate what kind of sanction we're talking about. So when we're talking about sort of broad sanctions against Russia, for example, the cost-benefit analysis, again, you do have to identify what your objective is. And if the objective is to stop the war, then these sanctions are not going to be effective. But what I'm really getting at more precisely are the targeted sanctions, where we're targeting, for example, Russian oligarchs. And the purpose of that is to try to pressure or to exert some pressure on Russian policy. And when you're talking about cost-benefit analysis, I think more to the point, you have to look at, well, what are the possible, due process or human rights violations that are part of this, right? I mean, do we have the right guy? What is the evidence that it's based on? Is it appropriate that we are effectively punishing because you're seizing or freezing assets? And more to the point, when you get to the suggestion that you're actually going to expropriate that individual's assets and assign them to victims as a form of reparation, you really are implicating serious issues of due process. Right? I mean, you would not be able to do that in a criminal justice system absent a trial and a conviction and so forth. So how is it that we are simply moving automatically beyond all of those procedures and expropriating an individual's assets before and without providing the information?
If I could get one more question to Ms. Marino.
I'm afraid not, Mr. Epp. You're a minute over. So we go to Ms. Chattel. You get the last question. You have 3 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. And first of all, I'd like to say that it's a real honour for me to join this extremely important committee. It's a real pleasure for me to be with you, with my colleagues who are so interested in foreign affairs matters. Turning now to the sanctions, we've got a recurrent theme coming out of the testimony, namely the need to have more direction, more transparency, more guidance in order to help companies to correctly navigate through the sanctions landscape. Of course, we're not talking about increasing the size of the state because we're in a period of budgetary restrictions currently, so we need to be creative. And I was wondering, well, Canada is not alone. We're imposing sanctions together with our allies. So is there a possible way of having a coordinated approach to sanctions, perhaps grouping together our resources so that we can have coordinated sanctions that make it easier to apply them then, or perhaps some multilateral agreements on sanctions? And then a second question, I'll take this now as well. Given that these sanctions are often very much related to the financial sector, would it be possible to collaborate with the experts from the financial sector together with the government and also contact professional networks such as accountants, lawyers and bankers, so we can really group together our resources, because we cannot open up 1,000 new positions. We're not able to do that. We have to be fiscally prudent. So I'd like to start with Mr. Martin, and then Professor Charon and Ms. Martineau, in that order, please.
Thank you. I mean, I do think that there is obviously a benefit in coordination. I think there is a fair amount of coordination now. But to your point, I mean, and getting back to sort of the arguments that Professor Charon has been making about transparency and reporting, that's rather difficult to do in a coordinated fashion. Like, so if you look at the United States, OFAC does report and does produce a great deal of information. That information may overlap, and they may be reporting on an individual who is designated both under American sanctions law and by Canada. But Canada has to do its own reporting, and in my view, if that individual deserves to know what evidence Canada is designating them for. You know, on what basis are they being designated? And that's, I think, a little bit more difficult to coordinate. It may be that there's information sharing as between the United Kingdom and the United States and Canada, for example. But at the end of the day, Canada still has to produce the information, produce the reporting. When you talk about
Je sais que j'ai pas beaucoup de temps.
I know I don't have much time, but would it be possible to get the answers of Madame Charon, Madame Martineau, Mr. Martin in writing? Because I'd be very interested to get your points of view on this. Thank you.
I have Mr. Chong has proposed that we have one more round. The reason being that all of your testimonies have been very, very helpful. Should all three of the witnesses agree, we just like to take another 10 minutes of questions. Is that okay? Excellent. So we will go to Mr. Chong first. Mr. Chong, you have 4 minutes.
Thank you, Mr. Chair. I'd like to ask one question about an issue that has popped up from time to time over the last 8 years that relates to sanctions enforcement, and more specifically to anti-terrorist financing and anti-money laundering. As you know, last year, new rules came into effect for law societies, from law societies across Canada that many people have said still gives the self-regulatory system too many ways to avoid AML and ATF rules. And critics have said that this self-regulatory system of law societies with respect to ATF and AML rules is just a smokescreen to avoid federal oversight. And recently there have been a number of reports that have highlighted this self-regulatory system as a problem. The Financial Action Task Force has said that exempting lawyers from federal oversight with respect to AML and ATF constitutes a significant loophole, especially with respect to money laundering in real estate. And the Cullen Commission concluded similarly in British Columbia, as well as a separate BC government commissioned report written by a former deputy commissioner of the RCMP, which concluded that, quote, lawyers are the black hole of real estate and of money laundering generally. In the United Kingdom, lawyers are ultimately overseen by the Financial Conduct Authority, which is an agency of the UK government, with respect to anti-money laundering and anti-terrorist financing rules. And so my question is this. Do you think it's time to enact federal legislation consistent with the 2015 Supreme Court of Canada ruling, Canada v. Federation of Law Societies of Canada, so that we can return to the pre-2015 system where federal authorities oversee lawyers with respect to anti-money laundering and anti-terrorist financing rules?
I'm hoping Dr. Martin can answer that question because that is very, very specific.
Yeah, I think that's really sort of outside of my wheelhouse. I haven't done a lot of research in that area, but as a lawyer, as a Canadian lawyer, I have to say that my intuitive reaction is to resist federal oversight, but I don't really have an expert opinion on that, sorry.
I would just add too, we're talking about provincial regulations, I'm sure, in jurisdiction as well. So, I mean, that's the wonderfulness that is the Canada federated system, but there are going to be several layers of jurisdiction to navigate.
Yeah, just to clarify, maybe to help give you some more context, up till 2015, the Proceeds of Crime and Terrorist Financing Act that was enacted in 2000 guided lawyers with respect to anti-money laundering and anti-terrorist financing rules. The Supreme Court struck that portion of the law down because it constituted an unreasonable search and seizure of lawyers, but also provided in its ruling a path for the federal government to enact new legislation that would allow for continued federal oversight. In the last 8 years, no legislation has been forthcoming, and so law societies themselves have undertaken to enact self-regulatory rules with respect to this, but many critics have said that you could drive a Mack truck through these rules, and it's a big part of why we've got significant sanctions evasion taking place here in Canada.
Thank you. Go to MP Oliphant. You have 4 minutes.
Thank you. And I'm glad to get back to Professor Martin. I found your testimony quite fascinating. And I want my first half, like we can take 2 minutes, on this issue of legality. And I'm not going to get into the seizure and repurposing issue because that's going to be a huge legal battle at some point. But just generally on pushing into sanctions and the legality, it seems to me they're legal until someone says they're not. I just want, it seems that, like, who would test that, and where is that? Because would that be in a domestic court, or is that in the international courts? When you say that they're illegal, under which laws? Is that under international or under domestic law? And has it been tested? And just help me, because it was kind of news to me the way you were talking about it.
Yes, thank you. Well, I have to say it would be very difficult to answer that robustly within 2 minutes, and I do commend the report that I wrote. But you're quite right. It would depend on which sanction, which context, whether it would be unlawful under international law, whether it would be unlawful under domestic law. I will tell you that in the European Union, a very famous case named CADI, the European Court of Justice, held that UN sanctions, when implemented by the European Union, were held to be in violation of the European Convention on Human Rights and were struck down, which was extraordinary given that UN sanctions have the imprimatur of law under Article 25 and under Article 103 of the UN Charter. Those tend to trump treaty obligations, and nonetheless, those sanctions were held to be violations of human rights law, precisely because the individual was not given notice, was not given evidence upon which the sanctions were based, was not given an opportunity to be heard, to make submissions, to test the finding, and to get removed from the list. So, if it was an individual who was bringing the claim.
I will read more that you've written. Thank you. And I'm going to commend it to our analysts as well. The last question I want to ask is about, I get confused in our testimony between what I would call enforcement and compliance. And it seems to me we keep mixing them up. Compliance has to do with companies, financial institutions, bodies, organizations complying with not dealing with sanctioned individuals and entities. And enforcement has to do with our government and its ability through CBSA and others to effectively do it. It would seem to me differences are required for each. So information that is public isn't as necessary for enforcement as it is for compliance, because these are companies that need to have information. So I just wanted to give you a chance to comment on that, because I think our committee is getting it quite murky between the two. Maybe Professor Charron first, and anybody else.
Yeah, no, I think you're right. I think I was trying to respond to the fact that I don't want to give the impression that sanctions are in place and then everybody, take a big step back and just wait for the RCMP and CBSA to swoop in and do something. We all have obligations, and you're right. So probably compliance is a much better term for that.
I would agree with that, and I think it's an incredibly important distinction, because I think there often is far too much emphasis on enforcement and looking at prosecution metrics, where compliance is actually what you ought to be looking at, and indeed sometimes there's overcompliance, right? I think when we were testifying in the Senate, a number of lawyers for people who were subject to sanctions were commenting on the fact that there tends to be overcompliance, and there's this sort of chilling effect, and so that's another aspect that has to be considered.
Go to Mr. Bergeron. You have 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. On Monday, we were discussing the fact that the government tends to really contract out its sanctions regime to the banking sector without actually giving any indications about our expectations. And perhaps that explains why the effectiveness is rather variable when it comes to enforcement of these sanctions. I'd like to come back to you, Ms. Marino. I didn't think I was going to have a few extra minutes, so I'm very happy. In the Marianne newspaper in 2022, you issued an opinion where you said that sanctions do not stop war. So perhaps sanctions don't put a stop to war, but we have to make sure at least that it actually can have an impact on the sanctioned states. So I'd like to come back to the answer you gave me previously, which was a very interesting one. But you admitted yourself that amongst these black knights that don't actually comply with the sanctions regime in spite of all of the incentives rolled out by the international community, which leads me back to my basic question. How can we actually put a stop to the action of these black knights that are undermining the effectiveness of sanctions? The best way to do this, as I said earlier, is to try and have as many partners as possible who apply the same sanctions regime or try to influence those who are not applying the sanctions so that at least they don't participate in the warfare effort with a sanctioned state. For example, with Russia, China is treading a very tricky line in terms of neutrality. It's not participating directly in the war effort. It's not selling any arms or the parts that would be needed for repairing or manufacturing new tanks or new fighter jets, but it is helping Russia by signing economic agreements. So China is the #1 economic partner with Russia, because Russia has to find an alternative to the European market. So there's not a good answer to stopping the Black Knights. If we've got more countries applying the same sanctions regime, then they will be more effective and have more impact. Sanctions do not stop war, but they do have an effect. They do have certain impacts, and it's important to have measures to be able to see the actual effect of these sanctions and measure that effect. Thank you.
Madam McPherson, 2 minutes.
Thank you. I'd like to ask these questions of Dr. Martin. I know you've said that it's very difficult for you to get the answers in the very short time that we give you. So whatever you can submit to our analysts would be fantastic, because your comments on the legality of the sanction regime that we are putting in place that has been proposed. It is really important. We were in Brussels, this committee, last year, and the EU was looking very, very closely to see what Canada was doing with regards to the seize and repurpose. So I'm just wondering, where should we look next? What are the other pieces that this committee needs to look at in terms of how we determine the legality of that? How do we do this work? How do we make sure that this is possible, or is it, in your opinion? You got a minute.
Well, the short answer to the last question is yes, I think it is possible. And I think that the committee could rely on more international law experts on the one hand, because there's an international law aspect to this. There's also a domestic law aspect to this. I really do think that individuals, Canadians who are designated as designated under these lists, have rights issues that implicate domestic law, right? So I do think that having legal experts advise you on the various aspects, and there are a lot of moving parts, there are a lot of different legal regimes, whether we're looking at human rights, whether we're looking at non-intervention, right? These are different aspects of international law, all of which I think do need to be considered. And I think that, as I said in my opening statement, I just would like to see the Canadian government be more mindful and be more informed of these international principles as they develop their sanctions regime. I'm not suggesting that sanctions regimes are necessarily going to be unlawful, but they do need to be informed by and based on an understanding of what the international legal obligations of Canada are. And just to refer very, very quickly back to something that the Honourable Member Oliphant said, it's not necessarily that if you are in violation of international law or perceived to be in violation of international law, that there's going to be some sanction against Canada or that there's going to be a prosecution of Canada. But the perception of illegality is hugely important, given that Canada stands as a champion of the international rule of law. And so to the extent that Canada is perceived to be violating the very principles that it's trying to enforce, or that it is vulnerable to accusations of hypocrisy, that's really important in my view. And that's why I think that taking into consideration the international legal principles is vitally important.
Thank you very much.
Well, at this point, allow me to thank our witnesses. This has been extraordinarily helpful. We're very, very grateful. I should also start off by apologizing for the delay when our meeting commenced. But again, as soon as this report is drafted, we will certainly be forwarding a copy to you. Thank you very much.
Thank you. This is a pleasure.
Thank you.
So, members, we will now be going into committee business. There's no one online, so we don't have any delays, correct?